What must a creditor do to perfect its security interest in an insurance policy? We explore that question in Genesis Merchant Partners versus Gilbride, Tusa, Last, and Spellane. Genesis Merchant Partners, a venture capital firm, loaned money to Progressive Capital Solutions on 4 separate occasions. The loans were secured by life insurance policies and other collateral. Genesis hired the law firm Gilbride, Tusa, Last, and Spellane to represent it in connection with the loans. Gilbride never sent an engagement letter defining the scope of Gilbride's representation. Gilbride drafted the necessary loan documents and filed financing statements for each of the 4 loans, one of which expressly identified the subject policies. After Progressive defaulted on 3 of the loans, Genesis contacted the insurance companies to collect on the policies. The insurers denied Genesis's request because they had no record that Progressive had assigned the policies to Genesis as collateral. Thereafter, Genesis sued Gilbride for legal malpractice, asserting that Gilbride had failed to perfect Genesis's interests in the policies. Gilbride countered that it had no duty to perfect Genesis's interests in the policies. Evidence adduced before the trial court established that the collateral assignment of contracts, which Gilbride drafted, clearly provided that Progressive, not Gilbride, would provide Genesis with proof that Genesis's interest in the policies had been perfected. However, the parties' emails conflicted regarding the scope of Gilbride's representation. The trial court granted summary judgment in Genesis's favor on the issue of liability. Gilbride appealed to the New York Appellate Division.